Good morning and welcome. It is Sunday, December 14th, 2025, and this is Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Welcome, everybody. I hope you're having a wonderful Sunday. I'm so glad that you decided to join us, carve out a little time on your Sunday to be here. So many people, I see those familiar names in the chat: Helen the Scottish Llama, Kathy Mama Bear, Proud Grizzly, Therapist Best Nancy, Seashell AZ, Jen Wowza. Thank you guys so much for being here. Appreciate you. Appreciate all your support. If this is a returning episode for you, welcome back. It's going to be a really great Sunday. When I was going through the questions, I was thinking to myself, question after question, God, that's a great question. That's a great question. So a lot of really good stuff today. Obviously, we're going to be talking a lot about Brian Walshe, but we're covering some other interesting topics and areas as well. So thank you guys so much, always for showing up with the questions and always for showing up on Sunday. If this is your first time, welcome. Let me tell you a little bit about what you're about to experience. First of all, my name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for about 10 years. I left to go into private practice as a criminal defense attorney. We decided to start this channel called Courtroom Confidential with the idea of presenting to you both sides of the courtroom. We hope that we do that. This show is called Sunday Fun Day. We have it every Sunday where we take your questions that you've left us voice messages about and we answer them live today. And it's a lot of fun. It's becoming my favorite thing that we do on this channel and for a lot of other folks too. So welcome. One quick message I do want to send. Mary Jubinville, thank you for bringing this up with the super chat. Says, my prayers go out to Friss and the family of those affected by the Brown University and Bondi Beach shootings. Please be kind. Yeah, if you were like me and many others, you woke up this morning. Well, first of all, you probably went to bed last night with news of this shooting at Brown University. Awful stuff. I think that suspect is still at large, last I saw, unless there's new reports. Please let me know. And then I woke up this morning to seeing horrible graphic video of a mass shooting with two shooters taking place in Bondi Beach, Australia. So I know that we have people who follow us and listen and supporters from both of those areas. Our hearts obviously go out. Our prayers go out. Really awful stuff to wake up to on a Sunday. I guess that's all I have to say about that. I mean, there's not much more that I could add other than it's just another tragedy that it seems like we're going to have to figure out and deal with now. But again, I'm glad that you guys joined us. I appreciate you being here. I appreciate all your support. It certainly is at least one kind of heartwarming thing that we can have on a Sunday. Best thing about Sunday is Sunday Fun Day, says Annalie Finch. Thank you so much for those kind words in the super chat. All right. Take a deep breath. You made it. It's Sunday, depending on how you look at it, how you set up your calendar. It's either the end of the week or beginning of a new one. Either way, good time to take a deep breath. Enjoy the next hour or so. Hit that like button if you haven't already. Subscribe if you haven't already. We would love to have you and share this with anybody that you think might enjoy it. And stay to the end. We do have some announcements and some fun stuff I want you to hear about. So please don't skip out early if you're able to. All right. Let's hop into the first calls this morning.
Hi, Josh. This is Polly from South Haven, Minnesota. And I have one question about the Brian Walshe trial. Why is the attorney Tipton attacking and aggressively going after the trooper, the witness? It was so hard to watch. You just end up having sympathy for the witness and getting angry because he's so frustrated when he's asking questions. He's just demeaning, aggressive, attacking. And even if he has good points to be made about the voicemails and such, it does make you have sympathy for the witness. And in a way, it changes the way you feel about it. And if I feel that way, I'm sure some of the jurors were getting sick of his attack style. Why does he do that? He should be able to make his point without being such an ass. And I'm talking about Attorney Timpton. Oh, and by the way, love your show and watch it all the time, every episode. Even when I miss, I go back and watch. And your Fox News stuff is awesome as well on Fox Nation. Love you guys. Thanks for what you're doing. Have a great weekend.
Polly, that was the perfect message to start out with. Thank you so much for your support and the kind words. Really appreciate you. Let's put South Haven, Minnesota on the map. There you are. Great question, too. And I like this. I like the way that you describe this because I think it's the way that a lot of jurors react to this. First of all, to Larry Tipton, I think he's a good attorney, by the way. He's in a very tough spot. I think I have sympathy for some of these defense attorneys being in tough spot because I am a defense attorney and I've been in some tough spots. And you just got a job to do. Here's what I'll say. One, some lawyers, and I don't know if that's Larry or not, but some lawyers have two speeds. You know what I mean? It's either stop or all the way go. And I think that sometimes people in cross-examination default to all the way go, and they just kind of don't know how to handle a very nuanced cross-examination. And I'm not trying to, criticize or throw Larry under the bus. He's an incredibly experienced attorney as well. Like I said, in a rough spot, but it just might be that when you got nothing else and you're not going to make much ground, you figure, let me go at least hard. Maybe that'll get this guy to crack. Maybe that'll rattle him a little bit. Maybe it'll convince some of the jurors. I think that could be part of it. But I always say, I think rule number 1 or 2, definitely in the top 5 of rules for a trial attorney, is read the room. Have a good conscious understanding, and this kind of is like a social awareness for how are jurors responding. I mean, that was one of my most important things, is constantly checking in with the jury, constantly taking the temperature of the room and realizing, is this playing? Is this working? Are they bored? Are they asleep? Are they on the edge of their seat? And you can tell if you're going strong after a witness and you take a look over at the jury and they seem unplugged or offended, back off, dial it down a notch or two from 11, get it down to something that maybe they can find to be more convincing. Because to your point, Polly, the last thing you want to do is be making good points and having that lost because of your attitude. The last thing I'll say is this, and I think this goes unappreciated many times when we're watching these defense attorneys, is many times they are playing to an audience of 1. Remember, the person paying the bills, or in this case, just their client, the person who is in charge of how this thing goes, essentially, is sitting right next to him. And that person may want this. That person may be saying, you need to be more aggressive. You need to go after these cops. Why aren't you getting up in this guy's face? Why aren't you asking these questions? A lot of times that's what's happening. They're not playing to the room. They're not playing to the media. They're not playing to the 12 sets of eyes looking back at them out of the jury box. They're playing to an audience of 1. And I think that's oftentimes can explain a lot of bizarre behavior. And I think that might have been what's happening here, is that, he's got a client. It's a sinking ship. It's going down quickly. And the guy is feeling like maybe he's in his ear constantly telling him he's not doing a good enough job and he's not defending him. So he decides to go out there and, go scorched earth with this trooper, and it just doesn't come off all that well. But thank you so much, Polly, for the question. And thank you, by the way, for the kind words about the new show that I have that I'm working on. Oh, Dr. Patrice Berry is here. Hello from Virginia. Excited to join before my kiddo to go play in the snow. Have fun. Make some snowmans. Make some snow angels for us. Good to see you. And by the way, good opportunity while she's here and in the chat. We're going to be having Dr. Patrice Berry on tomorrow night to talk to us a little bit about Brian Walshe. So thank you so much for agreeing to do that. And I'm really looking forward to that conversation. I got some questions for you, doctor. So be prepared. I got some real issues I want to get into with you about this gentleman, Brian Walshe. But back to the weekly rap sheet. It is a show that I'm very proud to be a part of. And I thank you, Polly, for the kind words about that. And just so you guys know, if you're part of Fox Nation, it's a streaming service. Every Friday, we now have a new show called The Weekly Rap Sheet, where we kind of cover everything that's taking place in the news. I co-hosted along with Paul Morrow, Donna Rotunno, two very experienced lawyers, and I'm very proud to be a part of that project. So please check it out when you get a chance. And check out tomorrow night's show with Dr. Patrice Berry and subscribe to her channel if you haven't already while she's making snow angels. What a better way to spend your Sunday. Allie Foley, thank you so much for the super chat, says a person of interest in the Brown incident was taken into custody at 3:45 a.m. at a Cranstown, Rhode Island hotel after someone saw the video they released. Very interesting. I have not read this. Thank you for that insight. We'll look into that, but I appreciate you sharing that updated news with us. The only thing I do know is that they had this one piece of surveillance of the alleged shooter walking away. And they were just asking for people, can you recognize this person from their clothing or the way they walk? And it sounds like if that is true, that they may have got somebody in custody. I hope that they have. Cheryl, thank you so much for gifting the Courtroom Confidential membership. I appreciate your generosity, and I appreciate whoever receives that. I hope you enjoy. All right, let's keep it moving here. Let's keep it rolling. Great question to start out with. Already we had a guest appearance in the chat, so let's keep it rolling. Where am I at? Here we go.
Hey, Josh, mods, and pals. This is Annie Kay calling from Santa Barbara, California. My late dad, Dr. C. Henry Kemp, Kempe, was a pediatrician and pioneer in child abuse prevention and treatment, so I'm close to the subject. He often got beyond the medical model of being a pediatrician and went into court advocating for children at risk. He helped pass the reporting law in the 1960s, which is why everybody is protected if they report suspected child abuse. And he always would advocate for kids at risk. In Melodee's case, why for a child who, whether alive or not, has no voice, can't a guardian ad litem be assigned to her in absentia so she has an advocate to be a voice and perhaps get beyond this impasse? Thanks for your thoughts and happy Fun Day Sunday, everyone. Bye.
Annie from Santa Barbara, what a great question. First of all, let's put Santa Barbara on the map. Thank you so much, Annie, for calling in again. Also, thank you to your dad. It sounds like he did incredible work. I appreciate that. I love this question. Again, smartest community on YouTube. So Annie's question is, we're all trying to be creative and think outside the box and find a way for more pressure to be put on this case, and the police who look at this point to have their hands tied to do something more aggressive and proactive to bring a conclusion to this nightmare story that every single day goes by and we can't find this young girl, Melodee Buzzard. Everybody's like, well, why don't they try this? Try that. Try, somebody last week suggested even something as clever as, how about Social Security benefits? Can they look into, some sort of proof of life on this young girl? Well, Annie's question has to do with the guardian ad litem assigned to her in absentia, meaning she's not around, but can we still appoint a legal guardian to her to advocate on her behalf? So helps us understand a couple of concepts. First of all, in absentia just means without that person, in their absence, without that person around. Sometimes you'll hear about a person being prosecuted in absentia. They're not around, they're a fugitive, but they're going to be prosecuted for a crime. Here, Melodee's obviously not cannot be located. We hope that she's alive and well, but we don't know, tragically. So can we have a guardian ad litem appointed for her, even though she's not present to be in court to have that done? A guardian ad litem is it's a court-appointed neutral party to advocate. They investigate and they represent a child. They are the guardian. I don't know what ad litem means. I should have looked that up, but they are the guardian of that person in substitution for another party. Usually you see this coming up in divorce cases. adoption matters, child custody disputes, or when the parent becomes incapacitated. And it's a situation where the government feels that, hey, there might be parties, mother and father might be at conflict with each other, or for whatever other reason, the child themselves need to have an advocate appointed who's impartial on their own behalf. Here's the problem in this case. You still need some sort of legal function to initiate that. Oh, Afton says it's for the suit. Well, there you go. I'm learning something every day. So a guardian for the suit. There you go. Makes a lot of sense. You need to have something filed. You need to either have a criminal case filed or opened up a Department of Child and Family Services matter. Needs some sort of case number needs to be assigned to this for whatever function, so that it can appear in court. In other words, you can't just show up to court and say, we want this thing done for this person. There has to be some sort of mechanisms to start that whole process. And that's going to have to either be brought by the criminal justice system or some civil mechanism, federal government, DCFS. Somebody's going to have to initiate something. And then something clever like this can be and probably will be done. And why we are all waiting for that to happen is kind of beyond me at this point. I'm of the camp that says, hey, let's kind of throw caution to the wind. Let's do something. And then if we have to kind of pick up the pieces later on because we were maybe a little too hasty, let's deal with that. I know that's not entirely the lawyerly answer to all of this, but hey, how long are we going to wait? Or are we just going to wait for tragedy before we do anything? So thank you so much, Annie, for that wonderful question, getting us thinking about these other kind of creative concepts that could be used here. Because this woman's not helping. I mean, I am beyond me to understand what is going through her head. But she is certainly not helping. And it's more disturbing and only makes you think that the worst has happened, that she continues to dig her heels in and not just say, she's okay. Here's where she's at. Check in with her and leave us alone. She hasn't done that. All right. Wow, June. Thank you so much, June Sidlauskas, for gifting 10 memberships. Appreciate that, June. Thank you so much. I hope you're having a wonderful Sunday. I know that now all of us and 10 other people are, so appreciate that. All right. And Cheryl has been a member for 9 months, everybody. Good morning, Josh. Good morning. Right back at you. Let's keep it rolling here.
Hi, Josh and CC crew. Longtime listener, first-time caller. My name is Jessica E. out of Raleigh, North Carolina. And I have a question about Alexee Trevizo. I mentioned it in the chat, and everyone was very kind to send a link to how to send in questions. So I have a question about Alexee Trevizo out of New Mexico, the case where she had her baby in the hospital bathroom and hid the baby in the trash bag, and it's truly a horrific case. I have a question about privilege and HIPAA. I work in healthcare, so I'm pretty familiar with HIPAA. And last I heard, her case is going through the New Mexico Supreme Court to determine what is ruled HIPAA and not ruled HIPAA. But I think the defense, her team, was also arguing like two different sides of HIPAA. It's very complicated and drawn out, and this case has been going on for a long time. And so I have a question of if the evidence from her hospital room, where the police was in the hospital room, but they were not interrogating her, and she was speaking to her mother, and she has extemporaneous utterances where the mom asks her a question and she says it wasn't breathing. If that is ruled that it cannot be used, could they use the hospital footage of her walking to the bathroom, holding her rear, for the baby to not fall out?
Jessica, thank you so much for calling in. A first-time caller. Always love that. I'm so glad you got up the courage or figured it out to leave us a message. Always love to hear new voices. Hey, it's me. Is that Jessica, Red Bunny? Well, thank you so much for calling in. Appreciate hearing from you. Let's put Raleigh, North Carolina on the map. And great question. Great question. You know, these are the types of questions that dissect these cases in ways that I think most people, passive listeners and viewers of the news, don't even understand. So I appreciate that. It is a little graphic. Here's what happened. We actually followed this story when it first broke. It's another kind of really sad and tragic case. You know, not entirely involving what I would call a hardened criminal by any stretch. But a young woman put in a really tough spot, made a really bad decision, but it could get incredibly serious for her because they're looking at perhaps murder charges here. Anyhow, this is what happened. Alexee Trevizo, she was 19 years old. She goes to the hospital with stomach pain. While people are outside of the room, this is all alleged, by the way. She goes into the bathroom of her hospital room there. Apparently she had was not entirely under watch at all times. There is videotape of her doing that. And later on, nurses find in the waste can of the bathroom a newborn baby, dead. Later on, she's being confronted by this. Police are called. And she starts making, to Jessica's point, some statements. And yes, some of them are, statements that are not in response to questions, kind of just her kind of making statements, things along the lines of it wasn't breathing, definitely inculpatory type statements. This case, though, the reason we haven't talked about it in a while is that a lot of these issues were brought up in court, Miranda issues, doctor-patient privilege issues, and they have appealed those up to the New Mexico Supreme Court. So right now, I should have said this is a case out of New Mexico. This all took place back in January of 2023. So it's already gone on for quite a bit of time because it's been kind of working its way slowly through the appellate system there in New Mexico. Here's the issues at play and why this is such a great question. First of all, there's doctor-patient privilege. So any statements that you're making to your doctor fall under privilege. The only way that is pierced or you can get around it is if the doctor needs to prevent future harm. You're about to harm your baby. You're about to harm yourself. You're about to harm another person. Then they can stop in to stop a crime or future harm. But if you're saying, Doc, I did this horrible thing, and yes, I was pregnant, and yes, the baby's in the bathroom in the waste can, that is privileged. Yes, HIPAA, and I see your question there. HIPAA's at play. HIPAA's not really the legal issue at play here, though. HIPAA has to do with like her medical records and all of that stuff. And that's something they're going to have to work through as well, because they're going to obviously want to get some of that medical evidence in at trial. But the issues at play with the New Mexico Supreme Court are these privilege issues, like how much of what she said to her doctors fall under privilege. The other issue is Miranda. When police came into the room, any questioning done of her, any statements she gave, were those abusive of Miranda? And should she have been Mirandized before they can get any of those statements? So, and then finally, the hospital footage. Can they use that even if all of this stuff they lose in court and they said, the statements are all out because of privilege of Miranda? Can they get the videotape in? Let's talk about that first. Yes, because a video is not statement. A video is just an eyewitness watching somebody. It just happens to be an eyewitness through a camera lens. So that is not that doesn't invoke any of the Fifth Amendment issues that we're concerned with, issues of privilege or issues of Miranda. That will absolutely come in. The only issue there might be an expectation of privacy. Now, I don't think she can claim that she expected to be all of her movements to be private inside of a hospital, and certainly inside of the hallway of the hospital. And I am almost positive that when you enter a hospital, though none of you ever notice it, there is some sign somewhere telling you you're under surveillance. So that's not going to be an issue. I think that's going to come in, especially as Dr. Patrice Berry says, especially a video in the hallway, not so much in the exam room. In the exam room, maybe you could argue there's some privacy issues at play. But getting back to the doctor-patient privilege, well, that will probably be problematic for the prosecution if they are statements made just between her and her doctor. But if these are statements that she's making while her doctor is present and police are present, that's no longer seen as privilege. Same thing goes with any other kind of privilege. When I am speaking with clients and there's attorney-client privilege at play, I will ask family members to step out of the room. You know, if I have to talk to my client to maintain the sanctity of that privilege, because if later on prosecution asks questions like, well, were you present when they were talking to the attorney? Well, then tell us what they said, because that's no longer privileged at that point. So that's one thing at play. The other thing is Miranda, and this always comes down to the idea of custodial interrogation. We talked about this a lot recently in the Mangione case. At what point, for the purposes of Miranda, are you considered to be in custody? Custody doesn't necessarily mean under arrest. Certainly when you're placed under arrest, that makes it far more clear. You got handcuffs on you, you're in the back of a squad car. I don't think any objective bystander is going to say that person's not in custody. But custody can also take place in other situations where you haven't been told you're under arrest or you're in handcuffs. It's an objective bystander standard. What would a person think as far as that person's freedom to leave in that situation? In Mangione, we're talking about him sitting in a McDonald's and two officers are talking to him. Now, his defense is going to say, well, those two officers have guns on their hips and badges on their chests, and he's in the corner of a McDonald's. He doesn't entirely feel free to go. However, case law and long history of this has said, no, we're not going to make every encounter with police custody. Some of that's just consensual contact. Some of that it's just you're talking to police. Police are allowed to go up and talk to people. Would that apply here? She's in a hospital room. She's in a bed. She can't just like jump out of bed and leave. She's inside of a room. There's only one door of an exit to that room. There's two officers standing there. Would she feel like she's in custody? Again, though, I feel like it's going to come down to police are allowed to talk to people. You can't just say every time cops enter a room and you happen to be there that you're now in custody magically for the purposes of Miranda. So those are going to be the issues that are at play here and what they're going to have to argue through. I wouldn't be surprised if some of those statements don't come in, but I still think that the prosecution feels fairly confident in proving this case, given that video, given some of the statements she did make that will be admissible, and given the fact that the baby was found in the bathroom. Really, really awful, horrible, horrible stuff. Again, she did a horrific thing. It sounds like she was just entirely unprepared, if that makes sense. Not mature, not skilled, not equipped with the proper tools to handle this. One other wrinkle I'll add to this whole thing. There's her mom, who seems very involved, very a part of her life. I don't know how else to put it. In other words, this isn't some sort of situation where she was a kind of non-involved parent, non-existent. She didn't have other resources. In other words, she had opportunities to come forward to someone and say, hey, I'm in a real rough spot. Here's what's happening with me. I'm pregnant. I don't know what to do about it. But she chose, for 9 months or so, not to do that, and then to do something really horrible and tragic at the end. So thank you, Jessica from Raleigh, for calling in and for asking such an excellent question. Let's keep it rolling. Oops. Sorry. Hold on. Forgot I got to press buttons.
Hi, Josh. Is Pam calling from Michigan. I have a couple questions about the Brian Walsh trial. First of all, when either side objects, I notice they don't give a reason for objecting, and maybe this was discussed earlier. I'm playing catch up on a couple recordings, but why do they not say anything, and how does the other side know what they're objecting to, or are they just guessing and redirecting their question? And my other question is, does the jury know that Brian Walsh has pled out to the other charges and that just the murder charge is on the table? So hopefully these aren't repeat questions. Somebody else already answered. Like I said, I'm playing catch up. So can't wait for Sunday and talk soon. Bye.
Pam from Michigan, always great to hear from you. Always a great question. And this is another one, really good question. Talking about the Brian Walsh case. Fantastic question, says CJ in LA. Good morning to you, CJ. I have to admit, I don't know if the judge made a ruling on this. Remember, this is the same courthouse that Karen Reed was tried in, and they didn't allow for I don't even call it a speaking objection. I call it an objection with grounds to be made in that case to everyone's kind of frustration and confusion. Sounds like the same thing was taking place in this case. I don't know if that judge made a ruling on it or it's just kind of the way they were handling this case. But to your question, how does everybody know? Well, it's kind of one of those things where if you've been doing this long enough, you know the issues at play as questions are being asked. You know if a question is going to elicit hearsay. You know if a question is going to ask for something inappropriate given a prior ruling. You know if a question is vague, ambiguous. These things, it's like everybody kind of knows what's happening ahead of time. You ever watched a football game and you've got a really great color commentator who can kind of tell you what each play is going to, how each play is going to play out? I remember Troy Aikman. I used to be so good at this. I think he's still commentating, and he would be able to tell you like what play they're going to run here and who's going to get the pass because they're just so good at this. They've done it so many times. They've got so many reps that they know what's coming next. A lot of that is what's taking place. You know the issues at play. And I think that's what was happening here, and when it doesn't happen is when you get these sidebars, which to me makes the whole process much more slow and bogged down. And I just wish they would allow for the reason for the objection to be given. Here's the other thing, not to go on a little tirade on this, but the rest of the country does it this way. And there's not some huge problem with jurors losing their minds because they happen to have heard the attorney say hearsay or foundation or prior ruling or whatever it is. I feel like jurors, it all kind of becomes just background noise anyways. So just let the whole process be simple and easier and grease the gears a little bit and get this trial going more smoothly. What I do understand is when judges are like, I'm not going to have argument as part of the objection. Objection, Your Honor, hearsay. He's about to tell us something that we've already talked about can't be said because he's got, when you get into all of that, some attorneys like to do that. That's a problem because then you're just kind of trying to testify in front of the jury, but give the grounds. I don't get it. To the other part of your question, do they know about the plea deal? No, they don't know. They just know that is conduct that's not on the table. They don't know that he's taken a plea to anything. And that's appropriate. That's not something that's for them to consider, whether or not he pled to some stuff. All that's for them to consider is his conduct and what he's charged with now. So he's admitted to certain conduct, and that's clearly in the record. He's admitted to lying. He's admitted to disposing of her body. That's all they need to know. That's the only thing that has evidentiary value. Whether or not he pled to that is of no consequence. And in fact, they could mistreat it. They could give it more weight saying, well, he's already said he's guilty, therefore he must be guilty of this, than it deserves. Think about it this way, just so that we all don't get hung up on this issue. They didn't need to charge him with that. They didn't need to charge him with disposing of the body or with lying to police. They could have just charged him with murder and still used all that evidence. In fact, most times I think that's how you would see this get charged, is just a murder case. And part of their evidence is that he disposed of her body. And part of their evidence is that he lied to police, all showing consciousness of guilt. And they don't need to independently charge him with those things. So, and still the conduct is the important part, not whether or not he was convicted of those things, not on a plea deal, but that he pled open to the court on all those things. So don't try to get too hung up on the idea that he's pled to anything. It's really of no consequence when it comes to the murder charge and what the jury should be considering. Great question, Pam. Always appreciate hearing from you. Let's keep it rolling here. We got a lot of Brian Walshe to cover. Lee Hillard, thank you so much for becoming a member. Welcome aboard. So glad that you decided to join the channel. And Kathleen Craghead has been a member for 5 minutes for everybody. Golf clap for Kathleen. I love this channel. Well, we love you, Kathleen. We appreciate your support. All right, where am I at here?
Hi, Josh and crew. This is Afton in Harper, Kansas. My question is about Sandra Birchmore and Matthew Farwell. I just saw that the federal prosecutors are not seeking the death penalty, and a lot of legal commentators and reporters are questioning that decision. So my question is, does the crime with which Farwell is accused meet the statutory requirements to go for the death penalty? Look forward to hearing your answer. Thank you.
Therapist, says, I know her. Afton, so great to hear from you. Always appreciate hearing from you and seeing you in the chat and having your support from Harper, Kansas. Let's put Harper on the map there. Are those, what are we looking at? Oh, you're zoomed out far. I thought that was just Kansas. Okay, there we go. There we go. Okay, Harper, Kansas. Yes. A lot of people shocked by this. Let's get into it, though, and I'll tell you whether or not I'm shocked by it. First of all, for everybody catching up, thank you so much, Robin Collins, for the super chat. Appreciate that. Very, very kind and generous of you. This is a horrible case. This is about as bad as cases get. Matthew Farwell is accused of murdering Sandra Birchmore. She was 23 years old. This took place. They gave us kind of a window of time between February 1st and 4th of 2021 in Canton, Massachusetts, bringing us back again to Canton. Talking a lot about Massachusetts today, and specifically Canton. The story goes, the allegations go, I should say, however, is that he was had a sexual relationship with her. He was abusing her. He was grooming her since the age of 15 when he was 27. Disgusting stuff. At one point, she becomes pregnant. She lets him know about this, tells him that he is the father of the child. We have since learned through DNA that he is, in fact, not, but he doesn't know that, which becomes important later on. He then shows up, allegedly, to her apartment, strangles her to death, and makes it look like a suicide. It was considered a suicide for a while until the FBI got involved, realized there was far more going on here, and he's been now arrested and charged with her murder, and later on charged with the murder of her unborn child. The reason for that being he was aware of the child, and part of the reason, at least according to the feds, part of his motive was to kill her because of the child, because he didn't want her and that child blowing up his whole life. Sure, he wanted to have an affair with a underage girl and continue to groom and torment this girl for over nearly a decade, but didn't want to have to be anything to do with the consequences of his actions. So, laying that out the way that I just did, if you, putting aside how you feel about the death penalty, a lot of people are morally objected to it on any basis. A lot of people are religiously objected to it. A lot of people just feel like it's something that we shouldn't have on the books. I understand that. If it's on the books, though, what kind of cases should it apply to? Should it apply to the premeditated first-degree murder of a woman who you had abused for years, that you then decided to kill, and her unborn child, because you essentially didn't want her to be a witness against you for the crimes that you had already committed? To me, yeah, that is the kind of case that it should be reserved for. Well, and is it eligible, to Afton's question? The way that the death penalty works in most states and federally is this. First, you have to have a death penalty eligible crime. That would be first-degree murder. Federally, even treason applies to that. But usually it's first-degree premeditated murder. Then you have to have some sort of aggravating circumstance. In California, we call it a special circumstance. On the federal level, they call it, they have a subsection 3592C of the Federal Death Penalty Act that outlines several factors that can be taken into consideration to decide whether or not to pursue the death penalty. Those include, amongst many other things, things like the crime was especially heinous, cruel, or depraved manner in committing the offense could apply here. Substantial planning and premeditation put into it absolutely could apply here. The vulnerability of the victim, I think, could apply here. Multiple killings certainly could apply. He's been charged with double homicide for Sandra's death and the death of her unborn child. And killing of a witness. And that's the one that kind of stands out to me. I think that this was entirely motivated because she was going to come forward about crimes that he had committed. In other words, exposing that she was pregnant because he was, grooming her from a young age. And he knew all of this was going to come forward, and he wanted to keep her mouth shut no matter what it took. So certainly I think they could find a clever way to make this death penalty eligible. And I think they knew that. That's why they gave this following statement I'm about to read to you. This is from the U.S. Attorney in Massachusetts, Leah Foley. She said, quote, "The United States of America by Leah B. Foley, United States Attorney, and Elizabeth C. Riley, Brian A. Fogarty, and Tori B. Cummings, Assistant United States Attorneys for the District of Massachusetts, advises the court that the Attorney General of the United States has directed the government not to seek the death penalty in this case." And that's all they really had to say about it. They didn't give a reason. They didn't give an explanation. They were just essentially advising the court of which statutorily they have to do. They have a deadline to advise the court if they're going to seek the death penalty or not. And they've said, no, we're not going to, because we've been instructed not to by AG Pam Bondi. And a lot of people have said, why? Why? And I get it. I understand it. I don't know why. They haven't really explained this one. I don't know if it has to do with the fact that he's a police officer. I don't know if it has to do with proof issues. I mean, that could be something. They could feel like, listen, this is a case that we're going to have a little bit of, usually you don't want to pursue the death penalty in a case where you feel like there might be some proof issues. I don't know if that applies here. But certainly when you look at other cases where the feds have decided to seek the death penalty and you compare the egregious nature of those cases to this one, you kind of go, doesn't this fall into the same category? Afton, there she says, I wonder if it was because it was a stretch to charge him federally at all. Could be. Gaining federal jurisdiction here could be on not the strongest of footing. I think there's also maybe kind of political issues at play, and that at the local level, it was considered a homicide. Now they're considering it self-harm, and now they're considering it a homicide, and maybe there's kind of jurisdictional politics at play. I don't know. Slow Momo says it kind of feels like that to me, that it's because he's law enforcement. I don't know. I think that they should probably explain, because a lot of people are reacting the same way, going, what, why not? And I'm not even saying why not because you did in this other case. So if you did there, why didn't you here? I'm just going based on the facts and circumstances alleged in this case. who else is the death penalty for but this kind of heartless behavior? All right, let's keep it moving here. I know that's a case that gets a lot of people kind of heated up. We're going to continue to follow that one as much as we can. And sadly, it's because it's in the federal court, we're not going to get cameras in court. So we'll try to give you as much on that as we possibly can. All right, let's keep it rolling. Great questions so far, everybody. Not my fault. I'm pressing all the right buttons.
Hey, this is Gloria from Florida. I'm in the Tampa area. I just had a question about the Brian Walshe trial. I just wondered why the last day before the state rested, the Commonwealth rested, why did Jem Mutlu have to be like pre-interviewed and they had to know what he was going to say before he testified? And then the last witness, the friend of Anna, Alyssa Kirby, she just testified. She just got up there and testified. I just wondered what was the reason for that. I couldn't remember if they explained that to us. Okay, thanks. That was my question.
Gloria, thank you. That was a great question from Tampa, Florida. Let's put you on the map. Jem Mutlu. What a character. I am not, please don't take anything I'm about to say as being disrespectful, but I just was kind of tickled at kind of right out of central casting Jem Mutlu seemed to be. I mean, he's wearing the turtleneck. He seemed like he was dressed kind of like a Bond villain. He's got this bizarre name, Jem Mutlu. And then it's like, apparently it can be spelled different ways, Kem Mutlu or Jem Mutlu. And I don't know. The whole thing was just kind of this fantastic little character thrown in the mix there. But before he testified, there was this hearing about kind of the way his testimony would play out, and they wanted to hear from him. This is what is called taking a witness voir dire. And it happens sometimes when you want to explore an issue that the witness is going to testify to either play out different objections or kind of make sure that the testimony comes out in a way that's not abusive of whatever rulings the judge may have made. But you need to do that outside of the presence of the jury, because you're not going to do this kind of dress rehearsal in front of them and then have them hear all this stuff that the judge is going to order they're not to hear. So that does happen sometimes, and it's called taking a witness on voir dire. The issue at play here was hearsay. Jem was going to testify to conversations that he had with Anna, which for the most part would be hearsay unless there's some objection. You can't just say, get up and start talking about everything Anna ever said. You're going to have a reason to allow that hearsay in. It's hearsay. Why? Because Anna cannot be cross-examined, because he's talking about out-of-court statements and he's offering them for the truth of the matter asserted. It's hearsay. But one of the exceptions to hearsay is a person's present state of mind. So if you're talking to somebody and they say, I'm so sad today, or I don't feel well. Also, present physical state is something that you can testify to. We've carved those out as exceptions because we're saying that there's probably some sort of inherent reliability in that when somebody's describing how they're presently feeling. Okay. This was the problem with our buddy Jem. When you're doing that, you're only supposed to testify to what the person said. You're supposed to quote them, not give your interpretation of, your summary of what that person was saying. Okay. Which he had a hard time doing. IGG Rock says, can't imagine how emotionally overwhelming it must have been to be feet away from someone who took the life and Brian did the body afterwards. Can't blame Jen for having a hard time. Yeah, he was struggling. And he was struggling because of the emotion of it, but he's also struggling because it's kind of an odd way of communicating. We don't communicate that way. when you say, what did you and Anna talk about? He was saying, well, she was talking about how they were having marital problems. If you're having coffee with someone, that is the normal way to communicate with someone. You interpret and summarize the conversation for somebody else. That's not how you testify, though. Where how you testify is very much more robotic. How you testify is, what did they say? Anna said she is tired because she's stressed, quote, unquote. Not, well, I felt like she was exhausted because of the marriage. And that's where he got into a lot of issues and a lot of trouble. And I don't think he could kind of wrap his head around that, because he kept on using phrases like marital problems and marital issues. But those words, according to Jem, never actually left Anna's mouth. Those were his interpretation on her words, his summary of her words. Yeah, Blue Bear says he also he kept saying, I think. There's another problem. I think means you're not sure. Well, we're not going to let you put in things that you're not sure about. You're quoting someone here, which is very shaky ground from a legal perspective, because we're going to allow in hearsay. But when you start saying things like, I think, and something along the lines of, or blah, 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 it's going to create issues. And so that's why they wanted to have him kind of play this out ahead of time and hopefully give him a little guidance as to how he should be able to testify. Dr. Patrice Berry talking about refreshing his recollection. I'm not sure why that played out the way it was. Perhaps it was because the police reports themselves didn't have actual quotes. That's a problem sometimes too, is the police report will be a summary of his summary. Jem said Jem believed she was having marital problems. Well, again, that might refresh his memory to the content of the conversation or the subject matter of the conversation, but not to the quotes, the words used. And that was the important part. This is very helpful for my brain. Thanks, Josh, this therapist. I'm glad I could be helpful to your brain. And so then they were talking a little bit about leading. The prosecution wanted to be able to kind of lead him a little bit more. Judges will allow that in certain situations, just to get through the witness, just to kind of help them get through this. It's not because you're trying to suggest answers. It's because you're trying to help them navigate waters that they're just not all that familiar with. So great question, Gloria. Jem, my buddy Jem, really kind of a character I will not forget soon. All right, let's keep it rolling here.
Hey, Courtroom Confidential crew and Josh. This is Ashton, one of the dudes calling in. I'm out here in Phoenix, Arizona. I know you're probably getting a ton of Brian Walshe questions this week, but I was just kind of reflecting on the case a little bit and have a question that is more general, but sort of related to the case. My question is, do lawyers ever bring in a third party, whether that be, another lawyer in the office that hasn't interacted with the case, a layperson, somebody in the office that is able to kind of sit in and view what the prosecutor or the defense even is going to present in the courtroom as if they were a juror, they're hearing about this for the first time, to make sure that they're actually covering topics from start to finish and it's making sense. I feel like sometimes when, these prosecutors and the people involved in the case have been involved for so long, 3, 5, 7 years, you've been staring at this for so long that some facts are just sort of inherent knowledge. And so then when you go to present it to somebody who's never heard about it before, are you in jeopardy of kind of skipping over some details that maybe you shouldn't, and you're leaving out details that you just know because you've been on the case for so long. So do people bring in sort of that third person to be that voice of reason and point out holes or point out places where maybe there needs to be more explanation? Thanks.
Ashton from Phoenix, Arizona, one of my dudes representing in the house. We got to get like a dude's flashing sign or something that goes off whenever we get a question. Thank you so much for calling in, my friend. Appreciate hearing from you. Great question too. The answer, your question is, do attorneys ever bring in consultants or kind of an impartial person or somebody in the office that doesn't know the case? to kind of run stuff by them? The answer to that is not enough. Not enough. And I agree with you. I think that this kind of myopic tunnel vision starts to happen with attorneys when they've been in a case for so long. Because you're looking at the case, you're trying to figure out your strategy. This happens for prosecutors as well, by the way. You're trying to figure out your strategy, your arguments, how you want to present the evidence, how you want it to play out, and how you want to, the lens you want the jury to view that evidence with. And when you're doing it, this for so long, down that narrow scope of viewing it, you start to ignore or discredit or underestimate the value of another perspective or other evidence. And I think it happens quite a bit, especially with defense attorneys. Back when I was working at a larger law firm, back when I was working with Alan, in fact, we would try to do that. Bring in somebody, we had enough attorneys around, bring in someone and kind of run the case by them. And it would happen quite a bit. I remember several times Alan would tell me about a case and I go, well, what about X, Y, and Z? And having had the background of a prosecutor, I could kind of view it that way. And he, there would be sometimes these moments where you go, oh, okay, that's more of a problem than I thought it might be. I think it's a real what's the word I'm looking for? I think that attorneys need to have a certain amount of, good attorneys have a certain amount of humility to be able to accept that maybe the way they're viewing it might not be the way that 12 jurors would view it. And talking about Brian Walshe, I think you're obviously where you're going with all of that is, did they run this idea of how she was found in bed, dead inexplicably by anyone? Here's the problem. I think they got that from Brian, right? I don't think this was an invented theory. I think that Brian told them that. And when Brian said he's going to testify, that's what they went with. They're not going to say, she fell down the stairs, she took her own life, she accidentally overdosed, whatever it's going to be, if Brian's going to go up and testify to something else entirely. So Brian, the only person who had the details about him nudging her and her falling out of the bed from him nudging her is this genius right here. So that's why they gave that in opening statements. Now, I think it was a mistake to be that detailed in opening statements. I think it was a mistake to, hang themselves out like that in opening statements. I always say, don't write checks you can't cash. They wrote a big check. They were not able to cash it because their client hung them out to dry. This is the reason why you're a little vague in opening statements sometimes as defense attorneys, because you're playing defense. Let's see what the offense does first and respond. Let's be counterpunching, not bringing in this bizarre theory that you're going to then have to support. And this is sometimes what happens. The other thing about this is, like, professional consultants, it's all an issue of money. I've been involved in a couple of cases where the client was very well funded and we brought in all sorts of the consultants, but most of the time you're not dealing with that kind of money to be able to afford to bring in professional, impartial people like that. But they do exist. And I think they charge too much, and it's probably a line of work I should go into. Dr. Patrice Berry says, I wonder if Brian always knew he wasn't going to testify. I don't think so. Who knows? If you're narcissistic and sociopathic enough to kill your own wife and then cut her up and bury her around Massachusetts, you're probably the type of person to, diabolically set up your own attorneys. I don't know. I just feel like there's no way they would have that kind of an opening statement if he hadn't told them he was going to testify. If he was on the fence about testifying and they still gave that opening statement, then that's on them entirely. That was a misstep of missteps. We have a CC dude emoji that lights up the chat. Oh, well, there you go. Thank you for that, Kaylin. All right. Farm Girl says, love this community. Thanks for welcoming me in. Oh, well, you are a huge part of it and appreciate you and your super chats and your generosity and your support and everything else. Oh, and thank you to the anonymous gifter for supporting our mods with coffees. Keep those mods awake. All right. Where are we at here? Find your place, Ritter. Here we go.
Hi Josh, hi mods, hi CC crew. It's Little Miss Red Velvet from Manchester here. I just want to reformat my question due to the fact that Brian Walsh didn't testify. I want to ask about the jury instructions, Josh. Can you just go through how they come about formatting the questions, where they get it all from, and what kind of questions would you be putting or instructions in for this jury? What would you put in them? Because I find it all very long and a bit confusing if I was on a jury. I'd love to hear what your thoughts are. Look forward to seeing you on Sunday Fun Day. Take care, everyone. I've loved watching the trial with all of you in the chat. We've had such fun. And thank you. So see you Sunday. Bye.
Little Miss Red Velvet from Manchester, England. Thank you so much. Always so great to hear from you. Yeah, let's give a shout out to the folks who are holding it down on Courtroom Confidential live trials. If you guys don't know, now you should know. We're on Verdict Watch, so you missed the trial. You could go back and watch it. We've got it up there on the channel. But we're on Verdict Watch right now on Courtroom Confidential live trials. That's our sister channel. You have to go subscribe over there at CC Live Trials. And it's got the best chat on YouTube, don't you know? So thank you, Little Miss Red Velvet, for being a big part of that. Okay. To the instructions. First, I should have shown you guys this. You got to realize these instructions are one of the most heavily litigated things in a trial, in the criminal justice system, are the instructions, because most appeals are based upon the jury not being properly instructed or the instructions not applying to the facts. The instructions are like the operative document given to the jurors. That it's supposed to tell them what they're supposed to do. And so much of it has been litigated. And you've got committees upon committees of lawyers and judges who weigh in on these things. And when you involve that many lawyers and judges, what you're going to end up with is a bunch of legal gobbledygook that's hard for people to understand. So yes, they're very long. Yes, they're sometimes difficult to understand. Just think about doing a group project with about 200 different lawyers and what that would end up looking like. And that's what you end up with these instructions. But it gives us an opportunity to discuss something that a lot of you asked about, which is how do the different degrees of murder work? And, where does this case fall with first degree, second degree, perhaps manslaughter? What does all of that have to do with? I'm going to do my best to try to make this as simple as possible, but know this. Lawyers don't get this stuff entirely. Criminal lawyers don't get this stuff entirely. I'm going to do my best. Forgive me if it's not as helpful as I hope it would be. I think the best way to think about murder and degrees is to start with second degree murder as your default. Second degree murder is the unlawful killing of a human being with malice aforethought. That's what murder, homicide is defined as, okay? So you've got a person killed another person with malice aforethought, meaning it was intentional, not accidental. You meant to kill. There has to be an intent to kill or a conscious disregard for life, okay? So if you start out with that, most murders are going to fall into that category. Well, then how do you get from second degree to first degree? You need some sort of aggravating factor. So think about it starting at second degree and then you aggravate up, okay? One of the ways that you aggravate up is premeditation. Well, what's the difference between premeditation and malice aforethought? Malice aforethought just means intent to kill taking place ahead of time, so not accidental. Premeditation means extra salt added to that. It is planning went into it, deliberation went into it, a specific intent to kill went into all of it, or other aggravating factors, extreme cruelty, torture, felony murder, a murder committed during the course of a home invasion. When you add these aggravating factors, particular planning and premeditation, then you're going to aggravate from second degree up to first degree. Okay, well, then how do you get to manslaughter? Well, you've got to go from second degree and mitigate down somehow. And you do that through, again, the intent. It all has to do with the intent, which is interesting when you think about it. We're concerned with the act, the actus reus, but we're more concerned with the mens rea. In other words, somebody died. You killed someone. That's one thing. But what were you thinking when you did it? Did you think a lot about it beforehand? You especially hateful in doing it? Or did you not think about it so much? And when it comes to manslaughter, were you in the heat of passion? Were you somehow inflamed emotionally by the current shock of a moment? Did it show that you lacked reflection or any kind of cooling down period? That would be like a heat of passion manslaughter. Or did you lack intent entirely and you just did something what we might call criminally negligent and therefore making it involuntary manslaughter? So to summarize, second degree murder, malice aforethought, premeditation brings us up to first degree. Lack of kind of reflection brings us down to murder or down to manslaughter and involuntary manslaughter. Make sense now? No further questions, no follow-ups? Good. Moving on. Also, make sure to watch this on Verdict Watch on Courtroom Confidential live trials coming to you all next week. How are we going to do that? Did we figure that out? When we know there's a verdict, we're going to go live. Is that the plan? Are we just going live every day showing a fan? Is that what we're doing? Oh, okay. All right. You won't miss a minute of that fan's action, everybody. All right. Little Miss Rev, what says, great, Josh. Thank you. I hope it was helpful. All right, let's keep it moving here.
Good evening, Josh, Tiff, Kaylin, Mods, and CC Crew. This is a bit of a generic question, but it's been kind of inspired by watching the Brian Walshe trial and the evidence presented there. How much could the jury rely on their own common sense, their own life experience, and their own reasonable personness in deliberations? I'm talking in part because Brian Walshe declared that Anna died of natural causes, and then this just got rid of her. So how much can they say? Oh, a reasonable person would have phoned 911, would have phoned for help, would have gone through the system and not done what he did. Thank you.
Helen the Scottish Llama, first of all, coming in with one of my favorite names. From Edinburgh, Scotland. Let's put you on the map. Great question. Love this question. Yeah, how much do we want jurors to use their common sense and be a reasonable person, and how much do we want them to be blank slate automatons in when they serve on a jury? I love this. The idea is that, yes, you're human beings. Yes, you have vast life experience. Yes, we absolutely want you to use your common sense. That's why we put this in front of 12 people and not a judge. We want the community's collective common sense to be a part of all of this. Yes, reasonable people. That's why you're chosen to be on a jury, is you've demonstrated that you are a reasonable person. Most non-reasonable people get kicked off by one side or the other because they cannot be reasonable. And and unbiased and use their common sense. And that includes what turned you into the person that you are today. And your life experience is naturally going to play a part of all that. Here's where things get a little weird, though, is if your life experience is going to cause you to be biased. In other words, have you been a victim of a similar type crime and therefore can't put it out of your head to judge this case on the evidence and the merits? In cases of, different type of sexual assault, child abuse, things like that, you will particularly get a lot of folks who say, they'll go privately to sidebar and say, listen, I've experienced something like this myself personally, or I know someone very close to me who's experienced something like this personally. I cannot serve on this jury. And sometimes a judge will press that person and say, listen, we're not asking you to pretend like that never happened. We're asking, can you put some of the emotion tied to that aside to judge this case based on its facts? And some people say I can, some people say I cannot. So that's where their life experience may play a role that makes them not not the right juror for this type of a case. The other thing you cannot do is rely on facts not in evidence, and that might include your own life experience. As an engineer or as a doctor, I know X, Y, and Z. Never heard from an engineer or doctor testifying during the trial, but I'm going to bring in my own experience in that profession and impose that upon the other jurors in deliberations. That's a big no-no. Or if you're saying things like, well, I've never heard of that. I've never heard of this thing happening that they told me happened in this trial. Therefore, I'm not going to believe it. You're not basing it upon the facts and the evidence. You're just basing it upon your kind of lack of life experience when it comes to something. Or I read in the paper that X, Y, and Z, and this wasn't ever introduced in trial, but I read an article that told me X, Y, and Z, and therefore I'm going to include that in my deliberations. So yes, common sense, life experience, reasonable person, but as long as that doesn't cloud your ability to realize that you're being given a very confined universe in which to make your decision in this case. To answer your question, though, as how it relates to Brian Walshe, Helen the Scottish Llama, yeah, of course they're going to sit there and go, seems like a very unreasonable way to behave, having found your wife, who you say you loved so much, dead, that you're not calling police, you're not getting paramedics, you're not even... My big thing is you're not concerned as to how she died and how that may affect the health of the other people in the house, your kids, you psychopath. What if she ate something bad? What if there's poison in the air? What if any of those things? As a reasonable person, would your first instinct then be to go Google best tools to dismember a body? Probably not. And I'm sure, and I'm hoping they will take that into consideration. Again, don't panic, guys. It's been one day. They used a lot of that day to just introduce themselves and figure out what they want to have for lunch. Okay. Don't panic just yet. Great question. All right, let's move it along here. Are you guys having fun? Are we doing good? Talking a lot of Brian Walshe, I know, but a lot of interesting ways of looking at the Brian Walshe trial that I think haven't been discussed all that much on this channel, at least, or anywhere else I've heard, for that matter. All right.
Hi, Josh. It's Monica from Omaha again. Like everyone, I thought we'd have a verdict, but here it is Friday afternoon at 4, and they are going home. So I have a question that since the jurors are unaware that he had pled to those other 2 charges, doesn't it make sense that they're giving a lot more weight to some of this other stuff, even though it's a dunsie? But USA, Omaha, Nebraska. Thank you. Happy Fun Day, Sunday Fun Day.
Monica from Omaha, Nebraska. Thank you so much for calling in. Let's put you on the map. Great question. About, again, getting back to this issue on the fact that they don't know he pled. It's really, I think the best way to think about it is it's inconsequential to this question before this jury whether or not he pled. Again, I go back to the point that they didn't need to charge him with this. They didn't need to charge him with lying to police. Many times you have cases where they lied to police and they don't get charged with that. Many times you get cases where they disposed of the body and they don't necessarily get charged with that. They get charged with murder. Don't let the tail wag the dog here. Just because there were these other charges and just because he pled to them is not anything that this jury deciding whether or not he committed murder should be concerned with. I mean, here's another way to think about it. Is there a potential for attempted insurance fraud here? Wasn't he looking into how to collect her life insurance? Could they have charged him with that? I mean, there's other things they could have charged this man with, and they didn't. And the fact that they did charge him with these things, I think, was just what they decided to do in that case that they felt might further bolster their arguments. But really, this is a murder case. This is not a lying to police or conveying of a body case. It's a murder case. And he just decided the best way for him was to not go in with 3 charges, but just to go in with 1. They are going to consider his conduct, though, in the same way that they would even had he not taken a plea. They're going to consider his conduct that he lied. That's the important part. The conduct that he hit her body. That's the important part. Those things show consciousness of guilt. Those things show a depraved, guilty mind. Those things show somebody who just committed murder, not somebody who just innocently found their wife dead in bed. Great question, Monica. Appreciate you calling in. All right. Good stuff today, guys. Really good. Great work, everybody. Pat yourselves on the back. Great work.
Hello, Josh. This is Deb from Arlington, Washington again. And I have a question about the Brian Walshe trial. It is Friday the 12th. The closings have happened and the jury has gone home. My question is about Larry Tipton's closing. How much of that closing came a little too close to facts not in evidence? And would you have objected? And how many times would you have objected if you had? And what would your closing have looked like? Thanks. Bye.
Deb from Arlington, Washington. Great question. I think you are asking something that was on a lot of people's minds. I know a lot of people watched Tipton during that closing and were, throwing tomatoes at their TV because you're saying to yourself, none of that was in evidence. How are you able to argue this stuff? Was he getting really close? Was he nudging his nose up against the line of facts not in evidence? I think so. I think he was seeing what he could get away with. Would I have objected? Probably not. I don't remember hearing him do something that was so egregious. And I think it has more of an impact on rebuttal anyways for the prosecution to be able to say, did you hear that pack of BS that you just heard? None of that was in. You're being asked to believe things that you heard no evidence of. I think it's a much more killer point to be made during a rebuttal than objecting to it as it's happening. The other thing is I don't like to object during closings. I'm trying to think. I think I've done it once or twice. Because I'm almost of the mindset that I want the jurors to be, when I was a prosecutor, I should say, I want the jurors to just kind of be tuned out and not paying attention anyway. So if I'm objecting, it makes it sound like I'm worried about what they're saying. And I don't ever want to make it sound like I even care what they're saying because it's a bunch of nonsense, ladies and gentlemen. And how would I have closed? Well, hopefully, if I were assigned this case, I wouldn't have had that opening that would have cornered me so poorly as the strategic blunder that took place in this case. But I think you would argue kind of similar to what I actually thought he did a fairly clever job. I mean, his argument was essentially the prosecution hasn't given you a way that she died, and they haven't presented to you premeditation. Therefore, unexplained sudden death is what you should believe. Yeah. You know what I mean? Again, he's confined by the check that he wrote in opening statement. I think I would have probably I think I would have gone for the like a manslaughter or second degree. Honestly, I think that's the best shot he's got here. And kind of leaned into that by saying there's no premeditation here. You do not have the level of premeditation required for first degree murder in this case. And I honestly think that is a problem in this case. I think there's arguments to be made. I think there are things that he did that show a boiling point, that show animosity, growing animosity, but are those premeditation? And in fact, if I'm the defense, I'm pointing towards things like the Google searches that he made ahead of time are about divorce, which to me shows a lack of premeditation. It shows planning for a life without her, but while she's still alive. Why are you searching for divorce if you're planning on killing her anyways? So I think that's where I would have tried to go with it, the whole thing. I think that this case appears to be much more along the lines of second degree murder, which still means he's going away for, he'll still have a life exposure. There'll still be something to life. I mean, he's not going anywhere, folks. Don't worry about it. And don't panic, everybody. Like I said, I'll tell you when to panic. I will tell you exactly when to start panicking, and it's not now. Great question. Deb from Arlington. All right, let's keep it rolling here.
Happy Sunday Funday, Joshua, Tiffany, Kaylin, mods, crew, family, guests, chat, everyone. Felicia K. Mayo, Humboldt, Tennessee. Let's talk about it, Joshua. Okay, I've waited all week for this, hoping somebody would explain it further. Now, treat me like I'm 5. Can you explain in very simple terms what a directed verdict, or in Massachusetts, the Latimore standard is? Best I can figure out, it's kind of like the opposite of an offer plea, only it's where the judge says, nope, not enough to even send this to the jury, so we dropping all the charges. Can you explain that further? By the way, congrats on 61K. Yay. Go CC. Happy Sunday fun to y'all. Thanks. Bye.
Look at you, Alicia K. Mayo, calling from Humboldt, Tennessee. The Latimore standard. See why we've got the smartest community on YouTube? Who's going around tossing around terms like the Latimore standard in casual conversation? I dare you, I defy you to find one of your non-courtroom confidential friends today and chat with them about the Latimore standard and see if they don't look at you cross-eyed. Great question, AKM. What is a directed verdict, or sometimes referred to as a judgment of acquittal or judgment as a matter of law? Well, here's what it comes down to. It comes down to burdens of proof. The burden rests on the prosecution. We talk about this all the time. The defense doesn't have to do anything. The defense doesn't have to put on witnesses. The defense doesn't have to cross-examine witnesses. The burden is on the prosecution, and a person is presumed innocent. So when you start from innocent, the prosecution's got to put enough evidence to get beyond reasonable doubt. Well, what do we do if they haven't reached that? If they put on their entire case and they haven't presented enough evidence to make it beyond a reasonable doubt? Are we expecting the case to continue? Are we expecting the defense to put on a defense? Are we expecting the jurors to even consider this? And the answer is no. We're going to give the judge an opportunity to stop this whole charade if it's that weak of a case. It's very rare, okay? Very rare. But it has happened. I actually had it happen on a case when I was the defense for it to be granted. And what you're saying is exactly what I just spelled out, is that they haven't reached their burden, Your Honor, by any objective standard. This case should not even be put into the hands of the jurors because they haven't even reached a standard most favorable to the prosecution. And that's what the Latimore standard is. It's the same standard in every state, but they call it the Latimore standard in Massachusetts. Quote, whether the evidence in its light most favorable to the Commonwealth, meaning give them the benefit of the doubt, notwithstanding the contrary evidence presented by the defendant, is sufficient to permit the jury to infer the existence of the essential elements of the charged crime. A really good example of this would be, let me try to think. I'm trying to think of a very clear example. Okay. Let's say that somebody was being charged with criminal threats. Okay. One of the elements of criminal threats is that the victim was in fear. Okay. What if you had the victim testify during a criminal threats trial and the prosecution asked them, were you afraid? And the person goes, no, not even for a second, not close. I didn't take that person seriously at all. I'm a big guy. And that little pipsqueak over there, yeah, he said a bunch of nonsense, but I wasn't in fear and I wasn't threatened and I can take him any day of the week. That's one of the elements. And now you've got a witness who said the element didn't exist. Why are you going to allow that to go to the jury? A judge in that case would likely give a judgment of acquittal, a directed verdict saying, no, you didn't reach it. I heard you didn't satisfy the elements of the crime, even in the light most favorable to the prosecution. And that's what a directed verdict is. That's what the Latimore standard is. And that's why you can see it would happen very, very rarely, because most prosecutions are going to at least paint the box of each of those elements to some extent. And then it's up to the jury to see if it's beyond a reasonable doubt. Great question. AKM from Humboldt, Tennessee. Always love hearing from you. All right, let's keep it rolling here, folks.
Hello, Josh, Tiffany, and fabulous mods at Courtroom Confidential. This is Calliope from Toronto. I have a comment or question about Tipton from the Brian Walshe case and closing arguments. As I listened to his closing arguments, I kept thinking, how on earth is he able to say these things with a straight face? I find Tipton to be a great defense lawyer, very respectable and credible. And I know that he's just doing what he has to do for his client. If his client has said, I didn't do it, he's got to go with that. And yet, how hard must it be to do that, to say all these ludicrous closing arguments, really? What have you ever been in that position, Josh, where as a defense lawyer, you know your client's story is likely, not true, and have you had difficulty, having to do a closing argument where it's untrue? I was just wondering how hard it must be for Tipton, and just wanted to hear your thoughts on how one would handle that. Thanks for...
Calliope from Toronto, Canada. What a great question. I love this. I love this because I think it gives us a little, perhaps, sympathy, empathy for what some of these defense attorneys go through. I know that they get criticized a lot. They get thrown under the bus. We go after them. We're like, that was ridiculous. How could they argue that? How could they do all this? Sometimes these guys are just doing a job. And I think that's exactly what's happening here. I think he did a admirable, serviceable job, and he had a really difficult case. Ann Pardo says, defense doing his job, this has to be the hardest job in a courtroom. It many times it absolutely is. How does he say this stuff with a straight face? I don't know. I mean, listen, do you think he's walking out of court every day, polishing his nails and patting himself on the back? I don't think so. I think he's just thinking, God, could we get this thing over so I can go on to my other crazy cases I have to handle? But listen, that's why it is an admirable job. He had to stand up, put on a suit and tie, stand there with a straight back and say, ladies and gentlemen, she died unexpectedly in bed. And that's what happened. And he panicked and he decided to get rid of her body. And that, as much as it's coming out of his mouth, he's probably having a hard time believing it. You got to stand there with a straight face and advocate, by the way, not just phone it in, advocate. So good on him. It's difficult. It's very difficult. Have I had to do it? Sure, not to this degree. Usually if I feel like my client's got a horrific defense, I'm going to tell them that. I'm like, we're going to go down in flames. How about you allow me to try to figure out some sort of plea deal that gets you out from under this without going to trial? That's what most clients want, by the way, unless they're looking at murder and the prosecution doesn't want to deal with them. That's what usually heads to trial. But for all the other kind of ridiculous defenses, you're saying no one's buying this garbage. We're not going into court arguing this. You need to figure out a way to get out of this. If I were in this position, though, you argue burden of proof. You argue they didn't meet their standard, ladies and gentlemen. It does sound ridiculous, but we're not the ones that have to prove anything to you. They're the ones that have to prove to you that he killed her and that he did it with premeditation, and they have not done that. But again, a huge strategic error was made in this case. I think they got too cute by half. I think they thought, okay, Brian, we got these Google searches. We can't explain them. We're going to be clever, and we're going to have you plead to that to explain the Google searches. And then you just need to tell us some good reason why you did what you did. And then they come away with this found her dead in bed thing, and that's all they're left with. They just shouldn't have said it in opening statements. I think they'd be in a much better position had they just said in opening statements, ladies and gentlemen, they're not going to be able to prove their case here. They're not going to be able to prove premeditation. They're, in fact, not even going to be able to prove to you how she died. And therefore, they are not going to be able to reach a burden of proving to you that my client was involved in all of that. And then just kind of sat down, let the case play out, and make their arguments in closing statements. But they didn't do that. Don't write checks. All right, let's keep it moving here. Uh-oh. It's that time. It's that time. We've got our last three batters. One at the plate, one on deck, and one in the hole. Sarcasm has been a member for 7 months, everybody. Golf clap. I only have 3 memberships. G was number 1, Grizzly, I'm guessing. You were number 2. You absolutely have Gisela to blame for having to deal with my shenanigans. You're welcome. Love you all. Well, we are our big thanks to Gisela then. Thank you for being here. Big part of this community. We appreciate you. And Caroline Fenton, 24, just became a member. Welcome, Caroline. I think you're going to enjoy it. I think you're going to have a good time. We hope that you do. All right. Who's going to bring it home for us? Here we go.
Hi, Josh. This is Mary from New South Wales, Australia, from the city of Newcastle. And I just want to say I love your show and I learn a lot every week. My question is, when you've been in the role of a defence lawyer and you've fought hard to represent your client and they've been found guilty, have you ever been secretly actually relieved because you actually knew they were guilty and you felt that the jury did the right thing, even though you fought as hard as you could for to represent them? I've got one other question, which is it true that you can't really say to the jurors, put yourselves in the shoes of the accused, like think about what you'd do if you were in their shoes? I was just thinking about that with this Brian Walshe trial. I feel like I want to say to them, what would you do if your partner suddenly died? And most people would not cut them up and hide them, I imagine. Okay, thanks, Josh.
Mary, thank you so much for calling in from Newcastle, Australia. Let's put you on the map. Love it. Love our Aussie members down there. Thank you so much for calling in. I don't know what time it is there. If you're listening now, if you are, let us hear from you. Thank you so much for the great question. Have I ever been relieved when the trial is over and I didn't win as a defense attorney? No. Not relieved is not the right word. I will say, what's the best way to put this? Begrudgingly not shocked. You know what I mean? I think every trial you go into, you try to convince yourself that you've got a shot. You say, yeah, you know, some of this stuff could convince people. Some of this stuff has some meat on the bones, these arguments. Maybe we'll you know, we could pull this off. Now I know you're asking about what if you've got somebody who's just guilty as the day is long sitting next to you. I haven't had a lot of situations like that. Like I said, usually in those situations, you're trying to get a plea deal. And in fact, I've never had a murder trial where, and you might find this hard to believe, but it's true. I've never had a murder trial where I went all the way to trial and I knew that this person was absolutely guilty with what they were charged with. Now, what more than happens is that you're frustrated that the jurors didn't convict them of something else, right? You're not entirely blown away by the fact that they got convicted, but maybe you've got a murder case that you thought was more of a manslaughter and you think those arguments were convincing, or you've got, you know, a different type of case that you feel like what they were charged with was overcharging and stretching, and there was something that they were likely guilty of, and you kind of argued to that and weren't able to convince jurors of. But, you know, initially you're kind of upset. You've invested. You've got that competitive juices flowing through you, and then as time goes on and the heat of it wears away, you start to go, well, what was I really thinking, anyways? Come on, but you know, I saw the evidence. Did I really think I had a chance here? To the other part of your question, though, about putting yourselves in the shoes of the defendant or the victim, even. Yeah, this is a big no-no. It's sometimes referred to as the golden rule argument. And the reason for that is we don't ever want to encourage jurors to base their decisions on emotion. And the thinking is that placing jurors in either the position of the defendant or the position of the victim plays upon fears and emotions and biases rather than the evidence itself. And we never want to do that. What you can do, though, is substitute the defendant for a reasonable person. So in this situation with Brian Walshe, instead of saying, as Brian Walshe, would you have done this? Would you have immediately searched for ways to dispose of a body after discovering your wife dead? Don't do that. Just say, no reasonable person is going to react this way, ladies and gentlemen. No reasonable person is going to find their wife and not immediately call 911 and not immediately go to the neighbors and say, I need help, and not immediately do about 1,000 other things other than pull out their laptop and start searching for how to dispose of a body. Those are perfectly acceptable arguments. But when you start asking them to imagine you're Brian Walshe, big no-no. Great question, Mary from Newcastle, Australia. Appreciate you. Say hello to all of our other Australian members down there. Brown B-Town Princess just became a YouTube member. Well, thank you, B-Town. And Maine Coon Mama Nicole also became a member. And there's the Maine Coon for proof. And then Ann Potter, thank you so much for supporting our mods with coffee. Appreciate that, Ann Potter. I miss anybody else? Little Miss Red Velvet has been a member for 3 months. We just heard from you. Josh, Tish, mods, love the channel, learning so much and having lots of fun. That's all that we want. Love the channel, learn a lot, have some fun. It's Sunday Fun Day after all. All right. Where are we going to next?
Hello, this is Sonia from Chicago. Hello, Courtroom Confidential. Hi, everybody. It's been a crazy week. And those of you in Courtroom Confidential live trials, I'm sorry, I've been so in and out. Work has been busy, but I've enjoyed being with you all so much. My question is sort of it's going to be about Luigi Mangione. It's sort of a follow-up from last week. We talked about how the evidence is probably going to come in. And if so, it might be likely that they'll come up with an insanity plea or some type of insanity plea, as you said, just a version of that. So do you think we're going to see a superstar dream team legal team again? Like in Diddy, like in Reed? I mean, if we see Brian Steele, does that mean it's all over for the state? As soon as that man comes in, I don't know, the not guilty start flying. So who do you think they'll call? Do you have any idea? What do you think is going to be? What do you think that team will be like? I'm kind of looking forward to that. All right. Look forward to your answer. Bye.
Sonia. Always love to hear from Sonia. Sonia from Chicago, Illinois. Let's put Chicago on the map. You deserve it. Gossip, rumor, and innuendo. Kathy. Oh, yay. I caught a live. We're so happy that you did. Just gifted 5 Courtroom Confidential members. It's very, very kind of you. Appreciate that. Your support and generosity. And I was on Kathy's show on Thursday. Please check it out, guys. We had a really, really great chat. I had a really fun time. And we're gonna return the favor and get Kathy on our show coming up here pretty soon. But if you haven't checked it out, go check out Gossip, Rumor, and Innuendo. And we talked about Brian Walshe, and go subscribe because it's a wonderful channel. Sonia, what about Luigi Mangione? What is he going to do for his defense? Is he going to get together a dream team? This is such a great question, but I feel like it might be a little bit over my pay grade. So I had to phone a friend.
Hi, Sonia from Chicago. It's Donna Rotunno from Chicago answering your question. So I do not think that Luigi Mangione, even if all the evidence comes in, is going to be able to go forward with an insanity plea. I don't think anything he has shown us so far, I don't think any of his behavior shows that he is unable to understand what's going on, even in a temporary insanity situation. I don't think he has a leg to stand on, given the fact that this was a planned attack. He had writings talking about it, so I do not think we're going to see an insanity plea. May we see a plea to something that would spare his life in the federal system, possibly, but in the state case, I think we are going to see a trial regardless of the evidence that comes in or does not come in. In terms of the dream team, he already has lawyers from Diddy, Mark Agnifilo and his wife. Those are his lawyers. Not so sure if we'll see others join the team, but I think probably what we see is what we're going to get, and that's a pretty solidified team as of now. Obviously, we know that they have a lot of money that was sent in the GoFundMe for his legal fees. So we'll see what happens. But I do think we're going to see this trial play out one way or another. I do not think we will see an insanity plea. And I think we're going to watch this thing happen. Thanks, Sonia.
It's Donna Rotunno, everybody. You know her. She, first of all, is a class act, and I'm so glad that she agreed to do this. So big thanks to Donna. Donna, by the way, is a celebrity, high-profile attorney in her own right. You can look up her resume. She's represented some really big clients in really big cases, so she knows what she's talking about. And I am very privileged to say that she is one of the co-hosts on the Fox Nation show that we have called The Weekly Rap Sheet. So it's myself, Donna, and Paul Morrow. There you see us all there. Check it out. Check it out. So to Donna's point, as far as a insanity plea, I agree with Donna that there's no evidence to support it here. You know, when we're talking about insanity pleas, we're talking about somebody who was so untethered to reality that they couldn't appreciate the consequences of their actions. And everything about this case indicates he absolutely not only appreciated the consequences, encouraged the consequences of his actions. But what I do think, to push back a little bit, is that they're going to try to introduce some elements of his psyche into this case. In other words, I don't see them going through this case and saying, without somehow getting in the idea that he felt incredibly wronged by the insurance companies, and that he became obsessed with the greed of insurance companies, and that he himself, apparently there's some sort of elements that he had back pain that had gone untreated, and he himself was so clouded by his pain and their greed and everything else that clouded his ability to form the proper intent and understand what he was doing. I would be shocked if we don't see that peppered throughout their defense somehow. Maybe not like an NGI type case, but I see that coming up. But does he have the attorneys to handle this type of a case? He absolutely does. Let me give you a little bit. First of all, Mark Agnifilo, who you see sitting there, just got off of representing Sean Combs, which I think is a win. I hate to say it, but I think he's got a win. I mean, Sean Combs is going to be in prison for about 3 years. He was looking at life, going away for the rest of his life, and he's going to get out in about 3 short years. Incredible. He also represented Martin Shkreli, if you remember him. He was the pharma bro. Look at this jerk. Such a punchable face. This was the kid that bought that pharmaceutical company and then jacked up the price to something unimaginable. There's Mark in the background representing him. Also Keith Rainier. This was this horrible case. You remember the sex cult NXIVM? He represented him. So he's got a tremendous resume. And his wife, Karen Friedman Agnifilo, is also a big time attorney, former prosecutor, big time attorney. And she's got a background in, you guessed it, mental health defenses. So don't tell me it's not going to rear its ugly head in some manner in this case. I think it absolutely will. And expect this to be an incredibly hard fought and litigated case because he is well funded. This guy is no Robin Hood. Okay. He is no hard on his luck, beaten down by the man, been through it, been through the ringer, living on the streets, did what he had to do, folk hero. He's a rich brat. He comes from an incredibly wealthy family from Maryland who owned country clubs and healthcare facilities. Okay. He wasn't exactly eating cold Pop-Tarts for breakfast. This kid came from money. And then on top of that, because of the disturbing support he's receiving, he's got it's not GoFundMe, it's called Give, Send, Go account set up. And the reports, if I'm wrong, please tell me. The reports are that it's raised $1.3 million. Mark and Karen are very happy about that. But that basically is a blank check for them to do and spend as much time as they need to defend this man. And already he's getting his money's worth because they got the terrorism charge dismissed. So I don't buy for it. That's the other thing that amazes me with all this support that you see for him outside of court. He is not of the people. Everybody views him as this, like I said, this Robin Hood type of guy. He is the elite. He's from a wealthy background, from a wealthy family, and now on top of that, getting all this money and support and everything else, and just showing up to court about as smug as you can be. It really, really bothers me. All right, calm down, Joshua. It's Sunday. All right, this is it, everybody. Last question. I'm going to give you a big warning, though. Don't you go anywhere after this last question because we do have some announcements for you. So sit tight. We'll do our last wonderful question, and then we're going to do some quick announcements for you. Best Nancy, thank you so much for gifting the membership. Appreciate you. All right, here we go. Oops. And we have a technical difficulty on the last question.
Hello, community. This is CJ in LA from Los Angeles. I hope you're all doing well and enjoying your holidays. So, Josh, my question is in regards to no body homicide convictions. It seems as though only a brief time ago in our judicial system, no body homicides were next to impossible to convict on. There were always lingering questions about the culpability or actual death. But it seems that lately we're seeing an increase in no body homicide convictions. Can you speak to this and what you think has changed in the way these cases are litigated and the way that the jurors are asked to consider the facts? Thanks so much. I really love this community and it feels like such a great family. Have a great day, y'all.
Oh, CJ in LA. It is a great family and it is a great community and you're a big part of it. So we thank you so much for this question. Great question. It does seem, I didn't look up the statistics if they even keep them, but it does seem like we're seeing more no body cases being prosecuted and prosecutors feeling more aggressive about prosecuting them. Why is that? And CJ, your question kind of goes, is there something happening in court and the way that they're arguing these things? I don't really think it's that. I think it's a offshoot, a consequence of our modern society just making people's ability to commit crimes and cover them up less possible. What do I mean by that? Well, advancements in DNA are just tremendous. So years ago, where finding trace elements forensically might have been difficult. Now, not so much. Now you don't even, the tiniest of a handful of cells can be enough to get a DNA profile that might be enough for them to link someone to somebody's disappearance and argue their murder. But even more than that, the kind of surveillance society that we live in now. I mean, think about some of these no body cases that we're talking about. Brian Walshe, he's captured all over Massachusetts going to different dumpsters. 10 years ago, certainly 20 years ago, did that kind of surveillance exist that we could have tracked his movements? No. And they wouldn't have had any of that evidence. That's what Dr. Patrice Berry says. Digital evidence surveillance. I think absolutely that's a huge part of it. What's another one? Suzanne Smith. What's his name? Brad Smith out of Texas. But it's Suzanne, right? His missing wife's name is Suzanne. What is his name? Brad Simpson out of Texas. Brad Simpson and Suzanne Simpson. Yeah, sorry. Remember, there's that video of his vehicle with the truck, with all the stuff in the back of the truck. That is, evidence that wouldn't have existed a few years ago that exists now that makes these circumstantial cases a little more impactful. And then as Deb in Indiana is pointing out, digital tracking. You can't go anywhere without your phone. And if your phone isn't tracking you, now your car is tracking you and saying exactly where the car's been and when it's been turned off and when it's been turned on. And your phone is telling you where you've done and who you've searched for and everything. All of these cases with the advancement of these things that are not necessarily law enforcement, but it certainly is a lot more evidence that can further add to that pool of circumstantial evidence, even in cases where a body doesn't exist. But great question, CJ. Really appreciate that. All right, guys. Don't cry, but also don't go anywhere. I'm watching. Don't go anywhere because we got some quick announcements for you. And to make it more fun, we're going to run a quick poll while we do these announcements because we wanted to run the poll, but we couldn't do it while we were going through the questions. Here's the poll on Brian Walshe, and we'll give you the results at the end of the announcements. On Brian Walshe, do you feel one, he's guilty, he will be found, not what you feel, but what will the jury find? Will they find him guilty of first-degree murder? Option B, second-degree murder. Option C, not guilty Option D, hung jury. What are your thoughts? We were going to try to put a time element into that, but we're not going to do that. We're just going to be, what are the results? So it's first degree guilty, second degree guilty, not guilty altogether, or a hung jury. We'll put up a poll and we'll give you the results after this. All right. While you are doing that and giving that serious consideration, I also want to tell you about a little website that you should all be familiar with, which is thecourtroomconfidential.com. If you go to thecourtroomconfidential.com, you will find three things. The three M's: messages, membership, and merch. What a great day we've had listening to all your messages and answering them. And if you want to have that kind of fun on your Sunday and participate, then go to thecourtroomconfidential.com and click on leave us a message. And that's how we know what questions to take and what to answer on Sundays. So please check that out. Also, membership. A lot of gifted memberships out today. A lot of new people joining. If you want to figure out how to join, the best way to do that in the least confusing way is go to thecourtroomconfidential.com and click on join the or become a member and join the CC crew. We put a lot of work into it, and we hope you guys enjoy it. And finally, click on the shop to find out about all our merch. And we've got a bunch of stuff available for you. T-shirts in about every color that you can imagine. We've got mugs, and we've got tumblers, and we've got, this is one of my favorites. We've got pajama pants, and we've got Christmas gear, new sweaters and T-shirts. Did we already do the Christmas gear already? There we go. Sleigh bells and subpoenas. I run on true crime and Christmas cheer. And I can't read the last one because my eyes are bad. I think it's, what is it? Merry motions and jolly verdicts. Bunch of fun stuff. Ugly sweaters, Christmas shirts. When's my shirt coming? Didn't we order me one? All right. Next time I'll wear my shirt whenever it comes so you guys can see it. But lots of fun stuff. Stocking stuffers, as they say. A therapist, says my shirt color, well, it's not exactly what she says, but shirt color, ask me about this shirt. I like that. That's a good one. Kathy Bomba Bear says, denim, he did it. Alicia K. Mayo says, distracted by denim and trials. What is this one? Indigo Indictment, says Afton. Isn't this our CC Crew blue? Isn't that the blue? One of my favorites. I love this color. Wear this one a lot, actually, in my real life. In my non-YouTube life, I wear this one around a lot. So we got this, plus a bunch of other stuff. Check it out on the shop. All right, what did you miss? Last week on Friday, we had the weekly roundup. We talked about everything we talked about today. Brian Walshe, Luigi Mangione, Tyler Robinson too. I know that not a lot of questions about that one, but he was back in court. This is the guy who's the alleged assassin of Charlie Kirk. Really interesting issues on courtroom cameras and whether or not media access will be allowed in that case. Talked a lot about that. And then you also missed there we go. There's the roundup. Oh yeah. The Rebecca Park case. Horrific case. Talked about all of that on the weekly roundup. And on Fox Nation, we had the weekly rap sheet with Paul Morrow, Donna Rotunno, who you saw today, talking again about Brian Walshe and Luigi Mangione. And that there's a new case about a cruise ship death. Not Anna Kempner, but a man who was served 33 cocktails in a day on a cruise ship and ended up dead. It's a civil case right now. It might turn criminal, but we chatted a lot about that as well. Really, really great conversations that we have between the three of us. A lot of times I'm either solo or talking to one person, but it was fun to kind of bounce ideas off of a couple of people. So please check that out on Fox Nation. Kathy Mama Bear says the weekly rap sheet. Oops. The weekly rap sheet is something good, I think she said, and then it went away. Is awesome, y'all. If you don't believe me, believe Kathy Mama Bear. All right. Coming up this next week. First of all, we're on Verdict Watch on CC Live Trial, so check it out. Don't go anywhere. Don't want you to miss that verdict. We're going to be following that every day, the action of the fan until we get a verdict. Or questions, by the way. Don't want to miss those either. On Monday, like I said, we're doing our true crime docket with special guest, Dr. Patrice Berry. I don't know if she's still in the chat, but she was earlier. And we're going to, from her channel, it's called Dr. Patrice Berry, Psychologist Reacts. And I really want to pick her brain about this man. And not just where does that hair come from, but what kind of a thought process goes into a person who kills their wife and then starts to search for ways to dispose of her body, and the amount of Google searches, and what can we say about that person's psychology. Oh, there she is. Good. I'm glad you're here. Study up. I got questions for you. But we always have a really nice chat. So we're looking forward to that tomorrow night, 5 p.m. on this channel, 8 p.m. Eastern, 5 p.m. Pacific, 8 p.m. Eastern. And then Wednesday, come back again for Wednesday Night Live with a guest to be determined. We're working on that right now. That'll be live at 5 p.m. Pacific, 8 p.m. Eastern, kind of your midweek check-in on all things true crime. One last thing. There is a new feature on YouTube that we have learned about and are trying to, oh, wait a minute, our poll. No, let me do this first and then we'll do our poll. One last thing. There's a new feature on YouTube that we're learning about that kind of helps boost the viewership or I don't know what it does. We're learning about it, but it's called the hype button. And apparently when this video is over, this button will appear. And if you click on the hype button, it just kind of lets the rest of YouTube know that you enjoyed the show and that others should watch it. And that will hopefully kind of help with the algorithm. I don't know. I don't know what YouTube does. They don't check in with me, but we're told that this is something that we should let people know about. Alicia K. Mayo says, congrats on 61K. Appreciate that. So everybody, you got a small amount of homework. When we're done with this, click that hype button. Let's see if it does anything. All right. What are the results of our poll? Everybody's looking at me. Do we have results of our poll? Who won? 1 second, she says. I don't got this cut in time, Kaylin. I'm a busy man. This is 1 more second. Is it tabulating? Is it computing? Is it calculating? Oh, she's getting so stressed out. I love it. Guilt, interesting. Guilty murder 2. Yeah, I seem to think that same way. It's close though. Guilty on 2nd degree, guilty on 1st degree. So vast majority, 95% thinks he's not going anywhere. 4% think there could be a hung jury out of this. You could be right, that 4%. I hope that you're wrong. And 1% say not guilty. Interesting. Well, I think it's going to be hard for them to walk this man out the door. I think it's really just going to come down to 1st degree and 2nd degree. And then just to ruin your whole Sunday, you remember Karen Reed and how things worked out in that, and that if they cannot all agree to acquit on 1st degree, they might not even get to consider 2nd degree. So you could have a hung jury in the sense that they don't acquit him of anything, but they just couldn't all agree that it's a 2nd degree and not a 1st degree. I don't know. I don't want to add more bad juju to the world, but I hope you remember in that case, they removed something from consideration, or that maybe I'm confusing it with a different case, but I don't know. I hope we don't run into those issues. We love you, Kaylin, says CJ in LA. I'm going to get grief from everybody from giving Kaylin grief, but she does a fantastic job. All right. That's it. There's our poll. Told you about the hype button. Big thanks to Donna Rotunno for answering our question today. Big thanks to our mods, Afton, Sonia, Kathy, and therapists. You know, you're all fantastic. And big thanks to Kaylin for putting up with me, and to Tiffany for being the best thing that ever happened to me. You guys are fantastic. Have a great rest of your Sunday, and we will see you here tomorrow, 5 p.m. Pacific, 8 p.m. Eastern. Take care, everybody.